Hi, everyone. Today's date is December 18th, 2017. We're going to talk about redressing a grievance when an agent of the U.S. trespasses against one of the people. So go ahead, Tom.
Thank you, Sandy. We have with us also Glenn and Sal. We have that we're visiting with, and Glenn is one of the best teachers of information that I'm aware of, truth that I'm aware of, and Sal is a good man that's out here from back east in New York, and he has problems that he's had some problems with the local Arizona police, and so
the sheriff's deputy, to be more particular.
Oh, sheriff's deputies. Okay, Sal. Yeah, right. Sheriff's deputies. Could you just give us a brief history of exactly what happened to you, because it's what happens to a lot of people. So it's kind of like we all know the song, but you go ahead and give us a brief description of your situation and specifically, and then we want to move and to address how you can redress that grievance as one of the people from that point.
Sure. So here it goes. Just a few days before Thanksgiving, Monday morning, I was traveling, and I got the emergency lights behind me going when I saw the sheriff's deputy car behind me. I pull over. He comes up to my window. I opened it up, and he first thing he said was, "You were doing 58 and a 45. Is there any reason why you should be going that fast?" And I looked at him and said, "Am I required to answer that question?" And he said, "No." And then he said, "License, registration, and proof of insurance." And I just looked at him, and he said it again, "License, registration, and proof of insurance." Well, what about it? He said, "Do you have it?" And I said, "Am I required to answer that question?" "Yes." "Do you have any weapons on you?" I just looked at him. "Do you have any weapons on you?" I didn't say a word. "Get out of the car. Out of the car. Do you have any ID on you?" And I said, "I have this passport right here." "Where is your driver's license?" And I would not answer. Turned around, put cuffs, and walked me into his patrol car. Slammed the door. Well, before he slammed the door on me, behind my truck, on the back window of my truck, I have a decal that says, "We the People," the Constitution. And on my bumper, I got a little sticker, one of those white, black oblong stickers, but it says Sovereign. And I have an Alabama tag, an Alabama dealer tag from a dealer in Alabama. So before he sat me in the patrol car, he said, "You're a sovereign citizen." And I said, "What's that?" And he said, "You don't kid me. You know what a sovereign citizen is." "I don't know what you're talking about." "Sovereign citizen is someone who thinks they're above the law. Do you think you're above the law?" I just looked at him. I said, "What are you talking about? I'm not above the law." "Because you have the Constitution. You're a constitutionalist." I said, "What? You're a constitutionalist. You got Constitution. Don't tell me you don't know what you're talking about." I said, Don't you have an oath to the Constitution?" And he started and said, "Well, yeah, but that's reasonable suspicion." And he slammed the door on me. And when he slammed the door on me, he didn't come back to the car for over a half an hour. Windows rolled up. 8:30 in the morning in Arizona, it starts to get hot. That morning was about 45. I had several layers of clothing on me and a hooded sweatshirt. And now I'm in the back of his car with the windows rolled up in a panic because oxygen's running out. And I was blacking out. So at this point, he had an accomplice show up, and they were searching my car with all four doors open. And in a little while, he walked over to me and said, "You have sovereign citizen paperwork in your car." I said, "What are you talking about? What do you mean?" So he then said, "Do I have your permission to open up your back? It's a pickup truck, so I wanted to get in the back door, which was locked. And I have a cover on it, which is latched." So I said, "You don't have permission for me to look in the back, and you don't have permission for me to be searching in my car, and you don't have permission for me to be searching anything." So basically let me stay there about another hour. Well, once in a while he'd open the door and let me breathe, but he saw that I was blacking out. And, ultimately, by screaming in my face over and over, he got me to give evidence against myself. And that was the whole point, was I didn't want to give evidence against myself. I was invoking my right to not give evidence against myself. And he held that against me. And he tortured me until I gave him a name. And, that's it. When the final thing was, I said to him, that's it, no more questions. I don't want to be bothered anymore. I want my lawyer. And he laughed at me. And then after another 5 minutes back there, he said, okay, if I unlock these cuffs, are you going to sign this paper? And I said, you want me to sign that paper? He says, that's not what I asked you. If I take the cuffs off you, are you going to sign this paper? And I looked at him, I said, man, I'll do whatever you want me to do, and I'll say whatever you want me to say. Just get me out of these cuffs and let me breathe. So he did, and I scribbled on the paper and got the hell out of there as quickly as possible, and I was thankful that I was still alive. And that's that. That's the story.
Well, great, excellent. Well,
no, I know I made mistakes, but
what occurred here, just in a nutshell, is a wrong was perpetrated against one of the people, a trespass that actually constituted a trespass against their unalienable, guaranteed rights to life, liberty, and property. Our body is our property. It's 80% water. It's body of water, our property. And they took possession of that property, as you described, and with absent a due process of law. Due process of law. So many people are not really clear on what due process of law is. They think it's some elusive, complicated thing, but it really boils down to simplicity. An affidavit of harm, either to person or property, by a real party in interest who has suffered the injury. And that's all it is. And absent an affidavit, in which a lawful affidavit is signed under oath with penalty of perjury by the injured party. So without that being in hand of that cop that did you wrong and constituted harm and injury and entrapment, absent due process of law, that's what occurred here. So that if you do research on what that type of behavior would be referred to as, you're going to probably find tyranny. You're going to probably find things that reference terrorists. It's so. Anyway, it's not good behavior. When it comes right down to it, it's absolutely not good behavior. So, good behavior constitutes. Let's just right now. I want to cut this before I go too far, and I want to get to the situation where you said. So then you went to court. You went to court on this citation. And I would like for you to go ahead and share with us what happened in the courtroom, how your rights were trespassed upon you.
Okay, so it was just this morning was the arraignment date, and frankly, I didn't even want to go, and I would not have gone. But the fact is, I have my wife coming to visit soon, and I'm going to be traveling around with her, and that's the last thing I want is to have a warrant looming over my head.
So you proceeded under threatened arrest, which is vitiates any contract right there. So anyway, go ahead.
Absolutely, I put my suit on this morning, and I went to that so-called court, and I sat there, and the so-called judge appeared, and then seemed like a kind, nice man, and he went over some procedural things about pleading guilty, pleading not guilty, and he pointed over to a woman who was sitting at the desk to the right of him and said that this woman takes care of situations where a victim is involved, and if there's a victim involved in your case, you can go and speak to her. And then he continued to talk, and the first thing I did was walk over to that lady and whisper to her, "Can I talk to you?" She said, "Sure." I says, "There's a victim in my case. Can I discuss this with you?" And she says, "Yeah, sure. What's your name?" And I told her my name, Salvatore, and she says, "You're not on this list." She said, who's the victim? I said, me. And she goes, what do you mean? I said, the sheriff's deputy victimized me. She goes, I'm sorry, you're going to have to speak to the judge about it. So that was that. And then I sat down and waited about another half an hour, and I could see that what everyone had to do is they walk up directly up to the judge, to that bench, to that bank, and they stand there, and the first thing he says is state your name and your date of birth. And everybody stated their name and their date of birth, and they whispered to the judge, and you can't really hear anything. So when it was my turn, I walked over, and he said, state your name and your date of birth. And I said, I'm the executor and administrator for all the accounts under the fictitious entity named Salvatore Menino. Here is my birth certificate. As you can see, is my date of birth is it says right here that it's August 23rd, 1977, although I have no firsthand knowledge of this. But I do see right here that 2 weeks later, on September 7th, 1977, that this trust was created, this corporate fiction was created, and I'm responsible for all the accounts of this. And he said, okay, fine. So I see, he reads it, and he looks, and he says, well, you're here on some charges, failure to identify, he mutters, and he's looking at the ticket, and he goes, and this, and that, and this, and that. And I said, I don't recognize any of these charges, and I'm not here I'm not prepared to make a plea today. I'm not interested in being a defendant in this case. And, in fact, it's going to be your sheriff's deputy that's going to be the defendant in the case. I fully intend to file a suit against him. And I had scribbled on a piece of paper a whole bunch of the statutes that Glenn and I worked out there that we're going to go after him with. There was a bunch of Arizona state statutes, including U.S. Code 18241 and 242, and another one regarding genocide. And I let him read that. And then what he said to me was, okay, I'm going to go ahead and enter a plea for you. I says, it's not my intention to plead, and I do not wish for you to enter a plea for me. And he said, I know, but I'm going to do it anyway. Those are his exact words. So he said, go ahead and speak to the bailiff. So I walked right beside him. Two young ladies were sitting there. One of them apparently was the bailiff. And she said, okay, you're going to come back here January 18th. Okay, sign right here. I says, I'm not signing that because that says I'm a defendant. She goes, no problem. I'll write in refused. But, if you're not here, they're going to issue a warrant. I said, thank you very much. Merry Christmas. God bless. And walked away.
Okay. I have to say, absolute congratulations, Sal. That was very well done. You could not have done it any better that I can think of. How about you, Glenn? What do you think? Is there anything else he could have done? I mean, he pretty much established the playing field for the situation and rebutted every claim that they made. It sounds like to me.
Yeah, I kind of think he gave him the case by bringing out the birth certificate. I mean, I wouldn't have. Date of birth is hearsay. Of course, I don't even go in there. Quite frankly, I can't tell you how many times I don't even go in there. And what I do is I just proceed with them with a criminal complaint and all the rest of it. But I can't. It's been a long time since I've ever been there, and all of this is magic. I mean, it's in other words, they're playing their little games. It's all designed to be psychological warfare against you, and it's all psychological. The judge's seat is up higher than the rest of where you're standing, like
right.
Some god or something like that.
It's intimidation. Yeah, the threat of intimidation.
Absolutely. And I quite frankly, I probably would have gone in there and said something like, so you must be the bought and paid for court masquerading as a judge, that kind of stuff. You know what I mean? But they probably would have thrown me out of there too.
But probably would dismiss your case.
Probably, I guess. I don't know. I've never, but I can tell you
that's
that.
Not my guess. My guess is that they would have entered a plea for him anyway, and then they would have issued a warrant for him for the next time if he would.
You're absolutely right, Sal. I have to concur with that because you have to understand they are a utility. They are a franchise, and that franchise each element of the franchise has to generate so much income to sustain the franchise. And they have to, no matter what they do at the end of the day, they've got to get a bond that will hold, so that they can start getting income coming in from it. Because they got them dropping off almost as fast as they're getting new ones coming in. And so to sustain themselves, they got to write those bonds. And
if they issue a warrant, it's not a real warrant. It's a fraud. That's
right. You're absolutely right. It's not a real warrant. But what you do, you back up before that. And that's what we're doing, is we bring an action which is a civil cross claim. Like you said you're going to do, that's what this is. It's a civil cross claim against, well, Sandy, in my case, we just targeted the cop who gave us the citation and his wife, because we do a civil, we do, well, actually, let me just fast forward here a little bit. It's come to my awareness that we don't have to do a notice of removal in a civil cross claim and try to remove that case, because the whole case is fraud. So we don't even want to recognize it in the first place. So now what we do is we bring an original action, because the law provides for all ministers, which we're all ministers of the ministers for the environment under NSA, but it provides for us to bring an original action. And we bring the original action in a separate court, which is the Environmental District Court for the Environmental District of the United States, a state division, division of Arizona State / county of blah, 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 / and then the name of the municipality, whatever municipality it is. Which municipality was it that gave you, that their employee gave you the citation?
Well, we're in Pinal County. The court is Apache Junction.
Okay, Apache Junction. So it wasn't a cop. It was the county's employees, the deputy sheriff.
Correct.
And so he's the one. And so wow. So he's the one pulling you over. He actually pulled you over.
Correct.
Wow,
They're
normally
people
those
over all day and night up and down Hunt Highway and Ellsworth. All day and night, their presence is there. They got everybody shook.
Yeah, well, yeah, because they're terrorizing the neighborhood. You know,
there's not one time that I travel through the area and not see someone pulled over. Not one time. And I'm up day and night. I drive here in the morning and back at night.
Yeah, there's revenue generators. You know,
yes, sir.
Glenn talks about them all the time.
He's the best.
That's what they are. That's exactly what they are. They are an employee of a business entity that is a franchise that is franchised under the state of Arizona, and which is franchised under the United States Corporation, and they're all franchised, administered by the mayor of the city of London. And the mayor is very important because the mayor is really the head dog here. See, what the United States Wastewater Management Franchise is an organization that operates under the Vatican. The Vatican owns it because the Vatican owns the city of London, and the Vatican owns the utility because the Vatican claims ownership of all land and all people. So the Vatican claims this right to tax the people and force them to provide the sewers, which municipal means means must. And so anyone operating within the franchise territory of a municipal franchise is in a situation to where the municipal franchise is then able to operate pursuant to codes, regulations, and ordinances that they themselves create to impose upon all the corporate inhabitants of within the boundaries of the municipality.
Well,
here's the deal.
Hang on, Tom. That brings up a point that I forgot to mention. It's just funny that the land I purchased is in the Santan Mountain region, which happens to be an unincorporated town, not part of the municipality. Just curious on your thoughts with that. If there's anything to be had with that.
No, that's a good thing. That's an excellent thing. And, only thing you need to do is figure out how to get a patent, a United States patent on that land. So then you can claim rights to it. Just like the technology that's mandated by federal law. I have 9 patents, United States patents. I was given exclusive rights to all commerce. And the Federal Water Pollution Control Act mandated the use of that technology or equal. And so I had exclusive rights to the commercial benefits that were to be realized as that technology, which was a product of primarily 6 U.S. patents. The other 3 are certain improvements, but it's a primarily is a product holding 6 United States patents. And a United States patent, what it does is it's a license from the United States that entitles the holder of that patent to exclusive rights in commerce realized from that particular technology when used in commerce. You understand that? Okay.
Mm-hmm. Absolutely. Well, Glenn and I have had much talks about bringing forth the land patent here on this land. It's something we plan to do.
And I think you can do that. And again, you want to be able to do it in the right venue. That's the main primary thing. See, the patent office, everybody thinks it's an agency of the United States, but it's not. It's a private organization that administers and manages all the patents for the inventors in America. It doesn't have anything to do with the corporate United States, and it has to survive on its own. Therefore, that patent issued by that entity is a lawful patent, because anything issued by a corporation has no standing at law. There are also any employee of any corporation lacks standing at law, because in effect what a corporation is a military-industrial war complex, an instrumentality of a military-industrial war complex of which the mayor is the kingpin for everything that occurs, because the mayor has the military powers of that municipal jurisdiction, and has the power to declare martial law, and is the direct.
I grew up in New York under Rudy Giuliani. Talk about martial law.
That's right, and it's the mayor. See, a lot of mayors don't know that they have this power, and the mayors that do know how they have this power, then they learn how to operate it to their advantage.
Sure.
And that's what they do. So what we're going to do is move to the who's responsible for your that individual giving you a citation. Well, he's a county employee. He's a county employee. Okay, so he's not a city cop. He's a county employee. Well, but guess what? He has a residence within a municipality, correct?
Correct.
That's right. He has a residence within a municipality. He does have a wife, correct?
Correct.
Okay. Well, then he drew first blood. Basically, it reminds you of that Columbo, not Columbo, it was what was
Rambo.
it? Rambo, yeah, he drew first blood. You know, it's so appropriate for this situation because this guy came up and kicked you in the knee first in the playground. You were just out there having fun, cruising around, and he comes up and kicks you in the shin. So
yeah,
you have a right to, because you're harmed, you suffer harm, so you have a right to redress your grievance against him. Because even these cops, I watched a video the other day, you know, when you say you're going to sue them, they all tell you, well, yeah, okay, go ahead. You have a right to sue. You have a right to sue. I mean, they don't mind creating jobs for the Bar Association. I mean, you know, go hire an attorney and sue us. And because it's in their court, no way you can win. But you have a right to sue. But when you take and exercise your right to sue and redress your grievance in the environmental court, it's a separate court and separate court system. And it was just recently, I don't know if Glenn got that or not, but it was just recently confirmed by a district court of the United States District Court in L.A. Central District, Los Angeles. A United States District Judge named G. And I think it was what was the full name of that judge? Dolly M.G. Judge Dolly M.G. in a ruling that she had to make that involved the environmental court, confirmed in her ruling that the environmental court is a court that is created by act of Congress and pursuant to 28, I believe it's Section 1651, has full right as a court issued created by Congress to issue writs in aid of its jurisdiction. So that means environmental means people. Environmental means living. If it's anything environmental has to do with water. And if it's doesn't have water, then it's dead, and it's not environmental. It's kind of clear and simple. So the first step that you must do is you must get it out of their jurisdiction. And the way you do that, the first step to redress your grievance is defined in the very first article of the Bill of Rights Amendment. It says we as the people have a right to redress our grievance. But however, wait a minute, that only applies to the people. That does not apply to agents of the United States, also known as citizens of the United States. So in order to justify the redress of your grievance, you have to qualify that you have a right pursuant to that that article of the Bill of Rights Amendment. Or you take and you proceed under environmental law that is available to all citizens of all classes. And that is provided for under Section 505 of Section 2 of Public Law 92-500, Federal Water Pollution Control Act Amendments of 1972, enacted October.
Have you heard of that, Glenn?
Yeah. Matter of fact, I'm looking at that Dolly MG document right now.
There you go. So that was the biggest thing that happened to us in a long time. See, the members of NSEA International, the NSEA is National Standards Enforcement Authority, and we recently changed it to international because it does have to do with international because all states are different states, and everything's international that has to do with environment, and that's the whole purpose of NSEA International and its members, which are all American nationals. So we're international as all being nationals. So, but that's the key here is to have knowledge of the fact that every one of the
copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries and other books and forms, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the military script, the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars.
Public servants, or let's call them agents of the United States. In the Federal Rules of Civil Procedure, it's clear that agents of the United States, when you bring action against agents of the United States, which would be anything that would be spelt in all capital names or would be an employee subject to the United States, any claims for civil action, and realize that people only have authority to bring a civil claim. They don't have authority to bring any criminal action. So it's not in our power to issue criminal complaints. It's in the people's power to execute tort actions in order to gain monetary benefit, which in turn makes the adversary homeless. And so that's what the environmental court is for, is to bring an action in the citation, which I attached there. Glenn, I attached the citation, which we call it, the citation, which is a notice of violation, a notice of claim for damages, and we also, the notary is executed, because the notaries are officers of the state, and their public law, Title 33, Section U.S. or United States Code, Section 1319A, says that the state is required to enforce and issue compliance orders. So being that the notary is the officer of the state, the notary is obligated to execute these documents when you take it to your notary. One of them signs it, and another one does a jurat. Your primary notary never uses her seal, ever at all. She only acts in her judicial capacity, and pursuant to the authority mandated her in her obligation or duty of care to the people, and that is to exercise her authority as a state official, and sign and bring the claim. If you can't find a notary to do that, well then, no problem. You as a citizen can do it. We also are now arranging our citations to where a United States Marshal can do it, because the United States Marshals, according to Section 566 of the, I think it's civil, the code, the Federal Rules of Civil Procedure, Section 566, which provides for the authority of the United States Marshals, which, by the way, have to execute and carry out the writs of all courts created by Act of Congress. So that's the benefit, is the fact that the environmental court has power and authority to issue the writs, and the writs have to be carried out and served by Act of Congress, by the United States Marshals. So that's also something I'll go ahead.
You mentioned that for the writs you need authority by the mayor of the town?
No, the writs will be issued to be served upon the mayor. Uh-huh. The mayor is going to receive the writs from the district, the environmental district court will issue the writs to the mayor, and the marshals will have the writ of execution to serve the writs upon the mayor of the community. So, see, here's the deal. Not only are these guys operating in violation of public law, congressional mandate, in violation of Section 31, 36, and 37 at minimum, which is the ones we have on our citation. They're operating in violation of half a dozen of them. But you don't need half a dozen because it's $1 million a day since July 1, 1973. So, I mean, it's how much do you want to bring against them? So we're just bringing a reasonable time for their first claim in violation of $1 million, and that's pretty reasonable compared to the total amount that they would be owing and due for the total judgment. If they were charged the full amount, would be in the neighborhood of about $6 billion. As provided for by statutory law, which is how you calculate all civil damages, have to be calculated on written statutory law in order to be justified by the judge. You know, the judge can't, when the judge, adjudicates, the judge has to adjudicate based on truth, law, and fact. The judge can't incorporate any opinions, personal opinions into the matter. So that's what happens here. Is the adjudication basically is focused on several. The adjudication is focused on several primary things. Okay, to start with, the way America was occupied was when Nixon put the bar in charge of all the courts in 1973 in order to assure that the Public Law 92-500, Federal Water Pollution Control Act amendments of 1972, were not to be recognized or enforced by any courts of the United States. That happened in 1973. That was his move.
Nixon put the Bar Association in charge of the courts so that they would not implement this public law?
Yes, that's correct. Absolutely correct.
And say that one more time. The name of the law passed by Congress.
It was enacted by Congress, and it was vetoed. It was vetoed when it was enacted. Nixon vetoed the Public Law 92-500, Federal Water Pollution Control Act, amendments of 1972. It was vetoed by Nixon, and Congress overrode the veto by 2/3 majority vote. When Congress overrides a veto by 2/3 majority vote, that constitutes a strict liability statute. That's a strict liability statute, means it's a congressional mandate, and it's non-discretional, and there's no room to not comply. So, in order to prevent, let me just explain that by the states moving to adopt and enforce, the federal government and the state governments and the municipal governments, which are were responsible to adopt and enforce this law under Section 510 of that law, which is state authority, Section 510 of Public Law 92-500, Section 2. And Section 510 mandates that the states, their political subdivisions, and all interstate agencies, which are corporations, were mandated to adopt and enforce standards and effluent limitations in the interest of public health, and they refused to do it. Those standards and limitations had to be the best available, nothing but the best available, or by equal, named or equal. So the best available is generally named, and then you got the or equal that follows it, so that you can't establish any monopoly, except for the Federal Water Pollution Control Act established a federal monopoly on the technology that met the requirements of best available demonstrated control technology as mandated under the National Standards of Performance, Section 306 of the Public Law 92-500, Section 2. National Standards of Performance. National means nation. Nation, when you look it up, boils down to the people. We are nation. The Federal Water Pollution Control Act was to protect the nation's waters. Protect the nation's waters. Well, if you look at nations, that's the people. The people of the nations. What are the people? We're each a vessel of the Lord. We're all vessels. And we're all bodies of water. We're 80% water, 20% land mass, 80% water. That's each of us. And in that state of being a body of water, then it's clear that jurisdiction comes into play. Jurisdiction comes into play in all elements and all aspects of this situation. So let's address that. The public law 92-500 makes it clear that these states, political subdivisions, and interstate agencies do not have any jurisdiction over the people. In the last part of that section 510, state authority makes it clear that if you don't adopt and enforce the Federal Water Pollution Control Act amendments, then you lose all jurisdiction over the water, which means the people. So that's one level of jurisdiction. Lost. You don't have any jurisdiction because you're not operating in compliance with the mandated effluent limitations and standards mandated by the law. So they lose all jurisdiction in the fact that they're not doing their job, okay? Regardless of who they are. They took an oath, they're not doing it. Secondly, the judge who told you, I'll do this, I'll do that. Well, to start with, that judge, in order to hold that position as a judge, is mandated to hold that position under Title 28, USC 451, definitions. He's a judge of the United States. And it says the term here is the judge of the United States under that Title 28 USC section 451 definitions. Judge of the United States includes judges of the courts of appeals, which is the environmental court is a court of appeal, district courts, it's a district court, courts of international trade, well, it could be a court of international trade, and any court created by act of Congress. The environmental court was created by act of Congress, Section 9 of Public Law 93-500. Section 9, environmental court. The judges of which are entitled to hold office during good behavior. There's a mandate here. You can't hold that office without holding that office during time of good behavior. So is discharging poison into your neighbor's drinking water through violation of Public Law 92-500, Federal Water Pollution Control Act amendments of 1972, Section 2, and Section 301, 306, and 307, wouldn't that be a violation? Wouldn't that be an act of bad behavior as opposed to good behavior? Of course it would. Any reasonable person would.
I got a little stuck there. What did you mean by poisoning the water? Where did poisoned water come in with regard to the judge?
There are violations of the Federal Water Pollution Control Act, which is what we're talking about.
Right.
The result of that is they're poisoning the water. They're drinking water unlawfully. They're violations. What's going on here is they are in violations of federal law that prohibits their discharging poisons from their human waste discharges, their toilet flushes, without a technology being applied right there in that federal zone, which lies between the building and the city municipal right-of-way. That's the federal zone. That's the part where the zip code applies to. Okay, that's between the foundation of your building and the right-of-way of the city or the county. Okay, that's a federal zone because there's a zip code attached to that. Well, that federal zone, everything within that federal zone has to be in compliance with sections 306 and 307 at minimum. Because it says in section 313 of the Public Law 92-500, and it can be downloaded. Just do a simple Google
I'm looking
search.
at it right now.
And you can go up at the top and do a word search, and you can put up at the top in the word search. You can type in a capital S, lowercase EC, and then period, and then space, and then type in the number of the section you wish to go to. For example, you can type in section 301. Go to section 301. That section is the first section that they're operating in violation of. And at the end of that section, it declares that chemical, biological, that the human pollution coming from human bodies being flushed in toilets at each one of these sources, which is defined as a building, facility, structure. We call them houses, and we call them, offices, and they call them courts. Any building that has a toilet in it must comply with these federal mandates. And their laws, which are codified in the USC, which are the public law is the law of the people. The public law is the public policy. Now, when we bring prosecution, we take into account the public law, which is a public policy created by Congress. But we don't prosecute them based on U.S. codes. Those are their guidelines as to what the limitations of prosecution is for the governing authorities they're all agents of the United States. So their U.S. codes, where the federal enforcement is codified into U.S. code, it confirms that their violation of these particular laws and these particular sections are defined as a criminal act that is punishable with a fine of $250,000 or up to 15 years in prison. That's a felony. That's a felony. Everybody knows if it's a $250,000 fine, it's automatically a felony. That's a standard fine for felony.
Anytime in jail is a felony.
Anytime over a year. Anytime over a year, and this is up to 15 years in jail. So it's a felony. Well, let's take a look at that. That's pretty serious, especially when it comes to the fact that a judge is committing this violation. Based on the fact of the California Constitution, Section 6, Article 6, and Section 18A says, basically, for what's pertinent, it says a judge is disqualified from acting as a judge when there's information or indictment available that suggests that he's committing crimes punishable as felonies under federal law. Let me say that one more time. A judge, according to California Constitution, which is full faith and credit in every state, states clearly that a judge is disqualified from acting as a judge when there's information or indictment available showing the judge is committing crimes punishable as felonies under federal law. Well, we have proof and evidence that they're all committing those crimes. What I sent to you, you know what I mean?
Yep.
We have proof and evidence they're committing those crimes. Now, you know, these people say, "Oh, they're discharging pollution." You know, how do you prove? How do you prove that? They flush it, and then, you know, how do you prove? How do you prove that? Well, it's real easy to prove it. It's real easy to prove it. Thank goodness that all that's been done for us. Generally, the way you prove it is you go test the water. And that's how you prove it's got pollutants in it, is you go do a lab test of the water. A chain of command, all that stuff goes along with it.
Drinking water.
In the industry, that's a standard procedure. When you do laboratory, anything going in the laboratory has to have a chain of command, a chain of custody.
Chain of custody.
And so, chain of custody. And so, basically, in order to now, we don't have to do that. All we have to do is know the zip code, which is the federal identification number of the land that has the source on it, that has water coming into it, and has water coming out of it. Are you with me here?
Yeah.
Okay. That source, like a house or a courthouse, what do you want to call it? You can put any building having a toilet that has water coming in and water going out. All right. Well, you know, the old saying is, what goes in must go out, or something like that.
Right.
So there is a site called ewg.org. It's www.ewg.org. EWG stands for Environmental Working Group. Environmental Working Group. The Environmental Working Group operates out of Washington, D.C. They went around, and at the turn of the century, they started going around to everyone, or mid, up into the latter part of the 2000s, I guess, around 2006, 2008, and back in that time. They went and virtually tested every single public water supply within the entire United States, which virtually tested every aquifer, which is a district, water district, sewer district, etc., of the entire United States. And fortunately, they have that database available, and all you have to do is go to ewg.org and just type in the zip code of the cop or the deputy sheriff or the whoever's bringing the action against you, whoever's making a claim against you, whether it be a cop. If in a foreclosure, it's normally a law firm or at least one attorney. And so the first step is to whoever's doing the wrong against you. What you want to do is, because now you have knowledge that every one of them who is an agent of the United States and subject to the United States codes, rules, regulations, and ordinances, and has a duty to comply with the congressional mandate in the interest of public health and welfare. Now you know that every one of them, every one of the cops, every one of the deputy sheriffs, every one of the sheriffs, every one of the board of directors, every one of the city council members, every one of the mayors are operating in violation of this federal law. So, now you got the goods on them. Because under Section 505, which is citizen suits, it provides for any class of citizen to bring an action against any one of the United States or any one of its governmental instrumentalities in Section 505A. It provides for absolute immunity under our Article 11 of the Bill of Rights Amendment. When you bring an action under this cause of action provided under Section 505 of the Federal Water Pollution Control Act amendments of 1972, Section 2. And I say Section 2 because Section 2 completely replaced Section 1, which was just an act which was originally enacted in 1948. And the difference between the two acts are basically, one is the first act of 1948 mandated use of public sewers, which is called public sewers. Publicly owned treatment works is the term that's used in the federal law. Well, the Section 2, which started Section 2 through Section 13 of the section of the Public Law 92-500, replaced the original Federal Water Pollution Control Act in its entirety. And because it became known that the public sewers, which are publicly owned treatment works, were the primary source of sickness and illness and cancer throughout the entire world, not just in the United States.
Sure.
That all the waters were being polluted, that Rome has used this business plan for kingdoms come, and I mean, be gone, kingdoms be gone, way before Christ. They used their drain courts. They organized drain courts. The sheriff went out and collected the people who didn't pay their taxes for the water drainage to go away. And that's where they came from. Their drain courts. They were organized to collect sewer taxes in Rome years ago and elsewhere. And so that's what they are.
Tom, please tell me you're in touch with Erin Brockovich.
There's a long history about that already. Erin Brockovich is now employed with Environmental Working Group. So that's a wonderful thing. I think that probably in the near future we'll have another opportunity to have a relationship with Ms. Brockovich. So we have had in the past, and that opportunity, what we're talking about here was so politically hot 10 years ago, okay? Because this is new, okay? The only thing that's new is the fact that we've learned that the party that through our court, which was convened in 2013, I think it was July 11, 2013 is when the Environmental Court was convened. So now we have a court, and the court can issue judgments, and judgments are required to be carried out by the United States Marshals. And so we can redress our grievances, and that's the main thing. And what we have learned also is due to the fact that these violations are also violations of the Lieber Code, which is the General's Orders 100 of the Lieber Code, and Section 16 and Section 70, which absolutely prohibits any form of chemical, biological weapon of warfare or mass destruction to be utilized in order to poison a population of a district. So, now that that's occurring within the jurisdiction of the mayor of the city, who is the one that has the military powers and powers of martial law, and the powers and is connected with the United States military, now he has an absolute duty to take action, because now there is a person within his jurisdiction that now has been charged with committing crimes of war crimes, within his jurisdictional territory. Correct.
I know what I want to be when I grow up, Tom. I want to be the mayor of this town.
No, because the mayor has full liability. Do you want the full liability for the wrong?
No, I like limited liability.
Okay. Well, here's the deal.
Do something about it.
Well, that's what the mayor's going to have an opportunity to do. Okay? There's a company called Advanced Environmental System that developed an environmental improvement program, which is, according to the requirements of that Federal Water Pollution Control Act, that every jurisdiction is required to adopt and enforce within their territorial limits of their franchise, of their municipal franchises, that would be in compliance with federal law. So each one of these, that will be one of the writs that goes to the mayor. The mayor will be obligated to agree to the terms and conditions to adopt an environmental improvement program.
Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit. And that's at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. And I've also got some videos uploaded to BitChute. This is my front page of my YouTube channel. Notice the arrow is pointing at the bell, and the subscribe button's already been clicked. That's why it's checked. Normally it would be red. And when you click on that bell, that one there is not clicked because doesn't look like it's ringing. When you click on it, a pop-up comes up, and there's a box you have to check to be notified about uploads. This is Steemit. The left arrow is where you click to upvote an article. The middle arrow is how many votes it's got, and the right arrow is where you make comments. And this is Steemit again, and the arrow is pointing at Crypto Wallet. There's a hand there. When you move your mouse there and touch the profile name, this pop-up window comes down, and that's where you can follow or unfollow someone.
To operate within his territory. Area of jurisdiction. Now, let me tell you something else. You know, we don't want to call these guys citizens of the United States. We don't want to call them straw men. We don't want to really call them any of those typical patriot names that we've been calling them, because in studying law, I've come to find out that I think it's under the Federal Rules of Civil Procedure. No, I think I'm sorry. I believe it's in fact under the rules of the United States Supreme Court. I think Rule 20 says that anytime an action is brought against an agent of the United States, the term is agent of the United States, not citizen of the United States. They're all agents of the United States. There are people of the United States which are contemplated in the preamble of the Constitution that define the joint tenets of the sovereignty of America, or for America. And then there's agents of the United States, which are the exact opposites and subject to the people of the United States. And now, according to law, anytime there's a claim, a civil liability that's brought against an agent of the United States, well, the amount that is superior to what the agent of the United States can pay is to be paid based on claim for the balance by the Treasury for the United States.
Where does it say that? Is that in the Clean Water Act?
No. That, I believe that's in the laws of the Supreme Court for the United States. I think it's rules of the Supreme Court. I think it's Rule 20, and I'll send that to you when I get back on the computer. I'll send you the complete study that lays that out. And actually,
yeah, that'd be great.
Yeah, because see, that's what they've been doing. We all been knowing that they've been bringing these actions against us, and they're not really fining us much. You know what I mean? They bring these actions, but what they're doing, they're collecting the bonds. They're writing these bonds, and they're collecting these bonds. I believe they're collecting the bonds through the mayor, which has the authority to issue all these charges to to the court. I mean, I'm not sure about this, but this is just based on what I've learned recently. The mayor has full authority to submit any claim, unpaid claim, to the Treasury of the United States for payment.
There you go.
Pretty interesting.
Yeah. So that makes a lot of sense. I'm looking at the Supreme Court rules here, going to Rule 20.
Okay, check it out. Just type in on it, do a find, and just type in agent of the United States. Agent of the United States. Agent. Just type in agent. See if you can find it.
Okay.
If you'll notice those rules, they have a lot of other rules in there, okay, that you can see and you can click on, and you can go to the next rule that's being referenced by that rule. And so what I've done is I've put together a complete study of each one of these rules as we enter into it and start to read it, and as it refers to other rules, I put the other rules as footnotes. So you can always refer to the footnote of that rule so you have a complete understanding as to what this rule is saying. You know what I mean?
Right.
And that's how you really do a good study to learn what the rules say. And that's where I've learned that there's nothing in the rules that refer to the citizen of the United States. Basically, they're two people. It refers to a person. There's persons of the law and the rules of civil procedure basically refer to the living person as a Title I, Section 1 person. It's referred to the separation of the living from the dead is provided by law, and as defined in the law, and the rules referencing to define the status and standing of the person, which are two basic classes of persons, and that is the Title I, Section 1 person, which is the living person, and then the other is the subject person, that is subject to all codes, rules, regulations, and ordinances, and more specifically defined in Section 5025 of the definitions in the Federal Water Pollution Control Act, which includes every individual, every corporation, every municipality, every state, every interstate agency, every association, and see what else is that. I think it says, it may even say a union, but maybe I don't know if that's in the RICO statutes and the definition of person, or if it's in the Federal Water Pollution Control Act. But it goes on to, underneath Section 309 Federal Enforcement section, you can go down to Section 3C or C3. Let's see, C, Section C, 3, and see that also any responsible corporate officer is a person. Responsible corporate officers cover all administration, heads of administration involving all municipalities, whether it be city, county, or state, or federal. They're all persons subject to subject to civil tort damages. And the tort damages available to the people are constitutional torts and then environmental torts that are provided under Section D of that enforcement, as provided also arising under the people's cause of action section, which is provided under Section 505, which is A, I believe it is, that provides that the damages for these actions, the civil actions brought by the people, are to be paid based on Section D of Section 309. So when you go there, you're going to see that in 1972, the fine for a violation of one of these sections, the civil claim for violations of one of these sections was $10,000 a day per violation. Well, now since then, we've incorporated what you're entitled to under the rules of civil procedure. You're entitled to adjust the damages to the current value, which brings it to about $60,000 per day per violation of any one of the sections defined under the Section 309D, which has to do with civil. And there's probably about 8 of them there. I know 6 of them. They're in violation of 6 of them minimum. And when you do the calculation, it's astronomical. Anytime a nation refuses to, or not a nation, but a foreign enemy of the people comes in and takes over the people, as they did on May 3rd of 1802, when the Congress enacted an act of Congress that was repugnant to the Constitution and is void from the beginning, de novo, was that act that they declared all domiciled in Washington, D.C. as corporations. They had to do that in order to adopt that was a part of the arrangement to enter into the acceptance and arrangement for the franchise from the City of London. The municipal franchise mandated that you had to declare every one of the citizens within your territorial limits as a corporation, because it was shortly before that. What was it, Glenn? Maybe was it 1786 or something like that? That it was declared that the corporation has no interaction with the living. So in order to impose their municipal services on us, they had to declare that we were all corporations. And that was an act that was repugnant to the Constitution, and as a part of that district court's order is going to declare that act void, non-pro-tunc, ab initio, because it was repugnant to the Constitution. It was repugnant to the law of God, because no man can declare the status of another man as an inferior absent that other man's consent. So that's where that comes from. So now what you've got is you've got the fact that they have no standing over us, because they claim they're standing because they claim we're corporations. Well, we just null and void the basic law of the land, which was the last law, which from that date forward Congress never had standing at law, but that's null and void. So now we've removed the presumption that we're corporation. Then what we do is we provide the facts of the matter that the judge is not holding office during a period of good behavior. Well, that voids the standing of any order or judgment or rule or warrant that has been issued against you, or any ruling, such as in your case, where he declared he declared that you were not guilty. Well, he doesn't have a right to speak or even a right to be in the courthouse, because he's disqualified from acting as a judge, because it's known that he's unlawfully in discharge of pollutants that are in violation of federal law. And it's easy to prove, because as we were talking about a while ago, you simply go put in the zip code at environmental worker, ewg.org, and you can pull up the list of the pollutants being discharged, and water coming in is water going out. So the federal law mandates that every single building put in technology to prevent pollutants from leaving that property, and you have a list of the pollutants that are leaving the property right there that are absolute prohibited as defined by this law. And so that's the violation. That's the justification for the violation. You bring it in a separate court.
Hey, Tom, we don't really need to go to the website and check, because I have a water filter at home that pure, perhaps I think it's called pure water filter, where it comes with an electronic pen and you can test your water. It just so happens to say that anything above 0.02 parts per million is unsafe to drink. And I tested the water in the city of Mesa, and it's like 700 parts per million. So it's way, way, way over intoxicated.
Yeah, but the advantage of having a
go ahead.
The advantage of having a website that does it is that theoretically that this is going to be scientifically provable, and so that's going to give you a lot more substantiation. Now,
it'd be validated. It's validated. Realize that when the environmental court lays down the law, there's no one can question it. So there's not any provable. That we don't have to prove anything. We allow them an opportunity to respond and rebut what our claims are, which they never do, Glenn, because they're all guilty. So there's no. And once you take action in the court of the people, there's no provable, because the kings rule. You see what I'm saying?
Right. Now, I'm looking in the Supreme Court rules. Rule 43 talks about costs, and it says that to the extent permitted by 28 U.S.C. 2412, costs under this rule are allowed for or against the United States or an officer or agent thereof, unless expressly waived or unless the court otherwise orders.
That's right. And when you read in there, when the court orders, realize now that it's your court, not their court, that's doing the ordering. The environmental court's your court. It's not their court.
Right, I understand. Yeah.
It's far superior to their court, and now it issues the orders. Their court's finished because we've completely disqualified the judge, because he lacks standing, because he's committing crimes punishable as felonies under federal law. So he's out the door. And now you've got the bar flies. And well, we know they're communist, so they're all corporations. Well, Article 11 guarantees us immunity from foreign corporations, from foreign entities. The ones of the United States are immune. That's us. And so, yeah, they really have nowhere to go. So what we basically do is then we bring the claim, and we fill out one of these environmental citations, we call it. That citation is for $1 million. You accuse them of violating the 3 primary sections of the federal law. That's the 3 counts that you charge them with. They have 13 days, according to Section 309, to respond, because it's urgent. It's an emergency. It's environmental. So the normal time period doesn't apply. The statutory time period to respond to a notice of violation is 13 days. They never respond because they're in violation. What they do is the first thing they do is they rush to their attorney. And they give their attorney, and they're laughing themselves all the way there, and they say, oh, this is those sovereign citizens, and now they've created a fake court. And that's what they say. And they laugh all the way down there, right? And that's what they claim. And they continue to be their little bad mischief selves, because that's what they do. But you have to follow through. At the end of the 13 days, you take the back of the certificate of service that I provided you. It it's one that we've used, so names have to be changed. Names, dates, and times, all that. It's a Word document. So the certificate has to be changed. But the back page of the...
My vid.me channel was shut down on the 15th of December, and YouTube channel called Sovereignty International is now free. YouTube changed all of their stuff, and so they were basically going to make that channel private. And so none of the videos would have been available, so I figured I'd just make them all free, except for the exclusive content. Now, the exclusive content is still there, but it's private, and it's available on my website. And I have 2 subscription levels, and I accept the cryptocurrencies. My one subscription level is $2.99 a month or $19.99 a year for the videos only. Then for also, you can, for $4.99 a month or $39.99 a year, you can get the videos plus unlimited consultations. Now, there's limits as to what I can do with my consultations. And because I am not a liar. No, I meant an attorney. No, I meant a liar. So what I do is I will tell you what I would do in a certain situation, and tell you where to find the forms. That's about the extent of the consultations that I would be able to do. But I would be available for unlimited consultations for whatever problems you have. Either for $4.99 a month or for $39.99 a year. The only power that these New World Order Satanists have over us is through fraud, deception, and my agenda is to expose it for all our benefit. And I cannot fight all the battles. I need more people fighting on point. And that's why I do all of this, so that people can understand what's going on. And when they challenge things, they can make sure they're on point. And so if you want to subscribe as a donation, I mean, it's certainly a modest donation, but every little bit helps. And a whole bunch of people chipping in a little bit, it adds up. And so it's all appreciated. I'm currently publishing a video a week, and I expect that that's the way it's going to be for a while. Some of the exclusive content is my Arlington private information share. I've got land deed training. I've got estoppel certificates training. I've got foreclosure estoppel certificates training. I got corporate denial training. I got toll roads notice and demand training, invoice training, notice of void judgment training. I've also got revocation of signature training, third-party witness training, federal habeas corpus training, revocation of voter registration training, criminal complaint training. I've also going to have lawsuit training. I've actually got a couple of criminal complaint training, and I'll probably have more. And then other training requests that may be requested, I'll put those up as well. Now, all the forms, files, and other instructions are available for free on my 2 private groups at Yahoo groups and Google groups. And so this training and the stuff that's in the exclusive content is really above and beyond what you really need. So if you want the training, then that's, you got to pay for it. But otherwise, everything else is free on my Yahoo group and my Google group. And the exclusive content will be on my website, and you can buy a subscription there.
Certificate, and it's extremely important that that's printed out front and back. The back page of the certificate, well, the front page is an affidavit that you served it. And that's the first thing that starts any case is an affidavit. Now, realize an affidavit's appropriate when you're bringing a claim. An affidavit is not appropriate when you're defending a complaint. It's just not appropriate at all. It's only appropriate when you're bringing a claim. So that's very important. You got to execute the affidavit. The affidavit is on the bottom of the citation, and sometimes the citation is filled out by a notary. It depends on if you know a notary. And we also have a notary presentment, a notary appointment, because we literally now have the authority as the court to appoint a state commissioned notary as to be a judge of the United States, as provided for under Section 451 of the U.S. Code. So then the notary becomes a judge of the United States, which makes it pretty, because you really need a judge when you do a judgment. Typically, a tribunal is all good, but a tribunal is not the judge. But you really need a judge when you do a judgment. And so it's always good to have a judge that is, in fact, has already been recognized as an officer of the de jure state, and then that person is qualified for an appointment. And also, along with the appointment comes indemnification, because they can't be a judge of this. So their status and standing is elevated to that level of the people, and doing judicial act for the people, as opposed to for the corporation. Good, that's important.
Okay, I'm looking in Section 309 right now, and I see some stuff about 30 days, but I'm not seeing anything about 13 days.
Okay, you do a word search. Do a word search. It's in the top. It's in the top section there. 13 days. Just do a word search.
Okay.
Just put in 13.
Yep, that's what I'm doing.
But not the word, not the number 13. It's written out for sure.
Yeah, and there's no matches.
Huh. Well.
But I'm looking in Section 309, and it says that it talks about he shall notify the person of the alleged violation and such state of such finding if beyond the 30th day of the administrator's notification. So this 30th day is what I'm seeing, not 13th.
What section is that?
309 of Public Law 92-500.
Okay, 309 what though?
Well, this is 309A.
Oh, 309A. So it's up. You're up in A. Okay. Well, it might be in another section, but it's 13 days. I know it's 13 days on there somewhere. So, and that's a statutory provision.
Well, I mean, this isn't a perfect. This is a this is a PDF file, and I did an OCR on it, and so, but the OCRs don't work perfectly sometimes. But anyways.
Yeah. Well, I'll find it. I know it's in there somewhere. I'll find it and send it to you.
Okay.
I'll find it and send it to you.
Now, Tom, you said that you have these court orders in place right now, and you're looking to get them executed by the marshals?
Yeah. See, what happens is the court, the court has authority to issue writs. Okay, writs have to be issued as a result of judgments. There's a lot of confusion out there that people think that the writ of habeas corpus is like a judgment too, but it's not. There first off has to be a petition, and then following the petition, there must be a judgment that provides, similar to the format that the district court Judge G laid out in her order of denial of that temporary restraining order that you read, Glenn. That's similar to that order. You just has to be laid out, and then that either justifies the petition is either granted or rejected based on the provisions of law. Well, the petition for writ of habeas is never denied. It's always issued to be written when the environmental court is involved, or the and for example, the writ of, let's talk about in your citation situation, that real small little citation situation. Let's talk about that. That's not going to require a writ of habeas corpus to be issued. It's going to require basically a writ of attachment to be issued, and a notice. It will be the writ of execution will be issued to the United States Marshals, and they have to, in accordance with the instructions to the United States Marshals, that are issued by the Environmental Court, that lays out how they carry out the execution. The instructions are virtually identical to the instructions that they have that was issued by the United States Bankruptcy Court. About the only difference is the requirements under the Public Law 92-500 that may vary a little bit as opposed to the Bankruptcy Court. But I believe that's the key is when you get the United States Marshals, and basically the marshal of the judicial district, there's one United States Marshal typically assigned to each judicial district. I would imagine there's probably more than one in L.A. County, for example, but I don't know for sure. But
I think there's lots of deputy marshals.
There's lots of deputy marshals, but I believe there's only one United States Marshal that's assigned to each district, isn't it?
That's
okay,
true.
Only one sheriff in a county. So
that's true.
So that marshal has a duty that's defined in, I believe it's Section 566 of, let me see if I can find that here. I just saw that. Here it is. It's Section 28 U.S.C. Section 566, which C basically provides in part that the United States Marshal Service shall execute all lawful writs, process, and orders issued under authority of the United States and shall command all necessary assistance to execute its duties. So it's coming down to, due to the fact that we have an environmental court that's a district court of the United States, and due to the fact that it was a court created by act of Congress, and due to the fact that the environmental marshals are the federal enforcement authorities that are mandated to carry out civil actions and enforce writs pertaining to civil matters on behalf of the courts, for all courts of the United States, the U.S. Marshals are going to be our boys. That's how we got to do it, Glenn. That's how it's got to be done.
Okay.
So we can go ahead and issue the citations, but the citations have to be responded to, and when they aren't responded to, we give them 30 days, despite the fact that I believe somewhere in there, I know it says 13. I've seen it a couple of times, and I've doubted it, and I went and found it again, so I know it's in there somewhere, and I'll send it to you as soon as I find it. But the bottom line is we give them all 30 days anyway. And so at the end of the 30 days, when they don't respond to those citations, which they never do because they're in violation of it, they go to their attorneys, and their attorneys confirm them with them, that the attorneys can't do anything with them, for them, because it makes it clear that the attorneys have no standing. They're not officers of the environmental court. They're only officers of the probate courts of the United States. So they don't respond. When they don't respond, then the notice, the declaration of non-response is then filled out. The declaration of non-response goes straight to the court because it's the back page of the certificate of service. So the party that you are bringing the claim against, they have opportunity to read on what the notice of non-response, the declaration of non-response states. And it basically states that everybody's in agreement due to non-response. All parties are in agreement. And part of the Federal Rules of Civil Procedure require that in a situation such as that, where all parties agree, such as a default judgment, for example, where all parties are in agreement, the judgment can only be for the amount claimed. So it's just a flat-out $1 million claim that's finalized. Judgment's finalized. A copy of the judgment is sent to the county recorder's office and delivered by the United States Marshal with a writ to the county recorder to convert the status on all properties over into the grantor status for the people of the United States. And so that's basically
up until now. You have the U.S. Marshals have brought the paperwork to the county recorders for you.
No, that's what I'm saying is what we have. The whole system is set up now to do this. We have not actually executed it, but we're doing it. We got all the paperwork. We're in place to where we can proceed now. We have several actions that we're just waiting for. But what we're learning is we've got people from being in jail for 3 years with no ground whatsoever. As a matter of fact, on the transcript, when the one witness that they brought that was the one witness testifying against this individual, she lied. She stated on the record 21 times that she lied. She was just trying to get her dad in trouble because she was mad at him because he grounded her from her phone for 24 hours. So she called up the cops and made a bunch of and said a bunch of stuff that made it sound like he was molesting her. And now he was incarcerated. They brought all kinds of charges against him. And at the first hearing they had, she testified 21 times when they were asking her questions. I lied. I just wanted to get my dad in trouble. He didn't do what I said he did. I lied. I lied 21 times. She declared she lied.
Once they create the bond, the district attorney doesn't let it go. This is happening all over the country. All over the country. Domestic.
That's right. That's right. That's right. They create the bond. And they can't let it go because if they let it go, they got to pay the damages. They got to pay the penalties. If they call it back, they got to pay the penalties. Isn't that the way it works? I'm not that familiar with the bonds. I have a general idea of how it works, but I believe if you call it in early, they buy it for so many years. Matter of fact, they still getting him to try to agree to 12 years when they have no witness whatsoever. Then they won't drop below 12 years. So they have to have a bond created for a 12-year period because they thought their case was so solid. And then it turns out that the bottom falls out from underneath it, but they continue to hold him. All right. You see what I'm saying? They continue to hold him. So in that situation, Glenn, who do you think that you would want to go initiate a $1 million civil action against?
Well, I'd go after the attorney.
Which one?
The prosecutor.
The deputy or the DA?
I'd go after them both. The DA is the guy that's responsible. His deputy is just following orders. But, you know, at any rate. But I'd go after them both.
Okay. Uh-huh. Yep. Well, there you go. That's see, that's what the difference is what we're learning is when you disqualify them and establish the fact that they have no jurisdiction. Let's see. My phone dying? No, my phone's not dying. We've been on here a while, so we'll cut it short. We can do it again. But when you what I'm learning is the judgment that's defined is the judgment.
My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profile, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group at Facebook called Sovereignty International is being deleted. Facebook is a has-been. I don't even go there. I haven't been there for months. But if I wanted to go there and ban everybody off my group, you know, that's the way I would delete it, because I'm not going to let Facebook profit from my hard work. Meanwhile, I have friends that are basically on there managing things, and you know, they can have at her for all I care. Anyways, my Yahoo private group is called Administering Your Public Servants. My Google private group is called Administering Your Public Servants. And follow me on Twitter at Engineer Win. Follow me on Steemit at Sovereignty International. And there's a link to my BitChute channel, although I don't have all my videos uploaded there. There's only a few. Well, there's quite a few. I've got quite a few, but still, it's not all of them.
It's all based on jurisdiction. Do they have jurisdiction? Well, if they fail in any element of jurisdiction, they're finished. Well, we just defined to you one element of jurisdiction that they fall under, that they fail under. Well, actually, we defined the one they fail under is the fact that they declare you have no jurisdiction to trespass upon a corporation because of that act of Congress, because that act of Congress was null and void. So that's all defined in a judgment, which would apply to any situation where someone did you wrong. That the fact that the judge is disqualified, it would apply to any situation where someone did you wrong. They're all disqualified. Every judge of the United States is disqualified because they're in violation of federal law. They have no jurisdiction. They have no standing. So that's disqualification. Well, you can't have a court if you don't have a judge. So by the time you do a counterclaim and take the house from the deputy sheriff and his wife and laden them with a $2 million judgment debt that will be over their head for the rest of their life, and you're entitled to 30% of their salaries from this date forward until the judgment debt is settled, and of course take their properties, all their assets, their bank accounts, all properties now come to you. And the sheriff has to go arrange for the United States Marshal is the one that oversees the collection of the execution on behalf of the court, not the sheriff. Do you see what I'm saying? Not the sheriff. Not the sheriff. We're above their inferior jurisdiction that uses sheriffs to do all that dirty work. We're with the U.S. Marshals. And the U.S. Marshals are authorized, according to the instructions to the U.S. Marshals, that if anyone obstructs justice, in other words, refuses to work with them, support them, honor the writ served upon them, then they're authorized to immediately issue a citation upon that person, the environmental citation. The one that's the standard procedure. They're authorized to issue one. We have one specifically designed for the marshal, where the marshal can fill it out himself He doesn't even have to have a witness. But, of course, there's always a witness. But he also receives a very large percentage of the total judgment debt collected. And now keep in mind, when we're talking about collecting debt, keep in mind that the United States Treasury is responsible to make up the balance that the agent of the United States can't pay by claim to the United States Treasury. So that's where we're headed with your situation. Is the first step, which I sent it to you in email, which lays out the first step, which you've already done. You've already completed.
Okay.
You've identified the full name of the one who trespassed upon you, did you wrong, and his wife, which they're one. In law, they're one.
Yeah.
So they both have to be charged because they're committing the same crime at the house that they flush toilets at every day. So now, by the time you get a $2 million lien, you take all their properties with a $2 million judgment upon both of them. Then I believe that probably that will send a message out to the rest of the deputy sheriffs in your area that are terrorizing the people.
Yeah.
That maybe that's not a good thing for them to do.
We have to teach them one way or the other. We have
That
to
only way. What I believe the way to teach them is to take and step back and look at what they've done to us, because they've been pretty successful in their whole business plan that they've executed against the people. And that's what we have to do. We have to step back and look and see what they've done to us. And what they've done to us is done everything that they can to destroy all of our sources of income, revenue, assets, and property. Life, liberty, and property. So what we must do in order to redress our grievance against them is we must strip them of all of their life, liberty, and property, basically their assets, and make them homeless. Because I know for a fact that when you're homeless, you really don't have a lot of time to be thinking about how you're going to do somebody wrong.
Ain't that the truth? So, okay, so this is what we're going to do. We already did the first part of it, and so you guys are going to prepare some paperwork to file into this case. Then, is that correct?
The next step that you want to do is you want to bring the claim an original action, and the way you bring an original action against anyone is simply executing the citation against them personally and serving it on them and you can serve it on them via priority mail, because priority mail has automatic tracking on it now with it. Okay. So you don't need to serve anything registered or certified. Priority is sufficient. And then you send both of the citations to the address that you're going to issue the citation in order to comply to their address, and that's their home residence. And then they will have 30 days. You give them 30 days, a customary courtesy of 30 days to respond. And then at the end of that 30 days, when they haven't responded, which they don't, they never do, then you fill out the declaration of non-response, and a copy of it goes to the court. A copy of it's retained by the party who executed it, who did the service, whether it be the notary or whether it be you, for a friend, best friend, or whatever. But the same party that sent it has to execute it's that address that has responded to. So normally we use a local notary, and the local notary will provide their address, and the response would come to the notary's address. So now when the notary executes the document, the notary says does the declaration of non-response and is witnessed via jurat by a second notary. So then that is sent to the court. So now you have two state judicial officers that are lawfully commissioned state judicial officers who have now sent a notice of non-response and a request to proceed with final judgment to the International Environmental Court. Environmental District Court. See what I'm saying?
Okay.
And then, the district court proceeds with the judgment. And as I told you earlier, it appears that the judgment is going to be relatively the same in all matters. Only thing that's going to vary are the different writs that are going to be issued in order to correct the problem.
Okay.
But we have to go after we have to do an original action against the court and.
Check out my other videos, Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 3, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft, Martial Law is Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts 1 through 13, Canada Border Pigs Playlist, Bar Members and their Satanic Connections Playlist.
The individual involved, is that correct?
No,
because we have to disqualify that so-called judge, right?
Well, now you're talking about the court, and then you're talking about the judge. The judge is not the court. So the court is the DA, but the judge.
So we still have to do an original action against somebody besides the individual involved because we got to disqualify him.
You do now because the situation wasn't handled before the hearing, the appearance, and now it's a matter of record that they have proceeded, that the judge has proceeded. The judge has has acted to proceed. So yes, have to. The part of the action that must be taken now is an action to disqualify the fact that the judge had any standing to proceed.
Right, exactly. Okay, so then the next question is do you have standard forms? I suppose I need to look at those documents you sent me. I think one of them was, let me look.
Yeah, we have standard forms that we've, we call them, I guess, forms really belong to the corporations, but they're standard documents that are used to administer the process. Yeah, it's a standard claim. Standard claim. It's $1 million claim. We don't go any more. Don't go any less. I mean, it's ridiculous to sue somebody for $10 billion. $10 billion. You know what I mean?
Okay.
It's just not necessary.
Okay. So we'll. Well, you just want to get their attention. And that'll get their attention.
Well, you want to make them homeless. Our goal is to make them homeless.
Sorry for laughing.
Yeah.
I mean, do I have your vote? And do I have your vote on that? Let's just make them homeless.
Absolutely.
Yeah.
Okay.
That's our goal.
So,
and of course, we disqualify the judge. You disqualify the judge. We got to disqualify the judge now because he's involved. So it's imperative that you find out now the name of the judge and also his wife and all the properties that are in his name, because you have to now issue a citation on every one of his properties. And generally, they have about 10 or 15.
Well, there's actually the judge and his boss, because what happened is we sent a notice and demand to the real judge, and what always happens in a situation like that is they start putting you on the round robin. In other words, they'll come up with a different judge, which they did. So we have the real judge that has stepped back from this case because we sent him some stuff that he didn't want to have to deal with, and we got this the new judge. So actually, we got a couple here. I think we should invite. Anyways.
Keep in mind too, Glenn, that the real judge is the mayor of the municipality in which that corporation is operating, and those people are doing their jobs. The real judge is the mayor.
Yeah, that's a good idea. Yeah, and what about the mayor of where all of this happened? Because where the show trials happened and where the original assault that took place against Sal happened was two different cities.
Well, you got to involve the mayor of both of the cities where you're going to go after the tyrants. You got to involve. So you got to realize
exactly.
Here's the whole focus of doing a civil cross claim or an original action involving environmental law against those who are violating environmental law, and that's because you have to go to where they live. So if the people that are involved in this action against Sal are in two different counties, well, anytime there's a party that's committing war crimes in any county or any municipality where there's a mayor, the mayor has to be involved because the mayor is the only one in the county that has military powers and duties and responsibilities. So the mayor has to be involved because what we're talking about here are war crimes. Matter of fact, in the last section of Section 301, you can look at the last section and you can see that they're referred to as chemical, biological warfare agents. Okay? That's what they are. They're chemical, biological warfare agents. And that is the BOD and the TSS and the acidic pH are the pollutants that are referenced in Section 301 that come from that are man-made. And the what we refer to as a stool is the BOD. It's referred to in the federal water, in the United States wastewater industry. It's defined as BOD, which is biological oxygen demand, and it's explained in the section that disqualifies the judges, the memorandum of law, which is going to be a part of the total judgment.
I'm seeing that here. I'm looking at it right now.
Yeah, and it's the urine and it's the bio of each one of us that are mandated to be controlled and contained. Now, the law in Section 402K mandates that technology in Section 402K mandates that technology, as mandated under Section 307, that has to do with defines prohibited pollutants and the particular effluent limitations that are and technology that's mandated in order to contain and control the discharges of these prohibited pollutants. It explains that they're harmful to human health, and that is where also I believe it's under Section 309. There's a definition of harmful, which cancer and such things like that. Matter of fact, the beautiful thing about this database in the Environmental Working Group is one of those classes of pollutants that it provides a list of. They have cancer behind each one of them. They provide you a list of all the carcinogenic pollutants, and every one of those are prohibited from being discharged from any home or any building having a toilet in it, and has been for 40-some years. But
just scratching my head here, Tom, wondering why won't they just put these effects in place for everyone's sewer lines? Why won't they just enforce it now? If it was passed by Congress, why don't they enforce it?
Money, big money, huge money. Those laws completely neuter 4 of their primary industries. One industry that it completely neuters is the wastewater management industry, which is an industry that generates about $1 trillion net per annum and also provides 40% of the budget of every municipality nationally. Well, when you implement technology to contain and control the pollutants being discharged at each source, in other words, nip it in the bud, then there is no sewer tax and virtually eliminates all water fees, because when you reclaim and repurify all of your water you use at the source in which it was used to a pure, potable, healthy, healing quality, then there's hardly any reason to bring in a whole bunch of more polluted water, because all the water you're receiving from the water purveyor is toxic. That's why you've got these guys, every one of them that you're bringing action against, you've got them absolute discharging, because the water coming in is the water going out. So when you look at the water purveyor, the public water provider, as provided for in the zip code under EWG.org, and that tells you the water that's the pollutants that are prohibited and not allowed to be in the water that are coming into the house in that zip code jurisdiction, because everyone that are receiving the water of that water company is not only receiving it, but that's a violation of the water company. But unfortunately, that's a violation of Section 302. But it says at the end of Section 302 that they can be exempt by the United States can exempt them from compliance. So you don't go after the water company, but the water coming in is the water going out. So now what you do, you have to go after the owner or operator of the source, which is the one that you're after. Does that make sense? Did I answer the question?
Yeah, I think you did. But what was that last part? The one that you're after.
Right, the one that you're source. After. The one that you're after, the person that you're after lives in the source, flushes a toilet at a source. A source is a building. A source is defined in Section 306. I believe it's 3 or 4 source. I know there's new source and then source. So I don't know, it's 3 or 4 underneath A of Section 306, which is really one of the primary sections that everything hinges on, is Section 306 and 307, because it states in Section 313 underneath federal pollution control, it says that not even the President of the United States can exempt compliance with Section 306 or 307. That's what makes it a congressional mandate.
Wow. Powerful.
Oh, big power. When you start realizing what this is, and Kennedy provided it to us, but it was kept secret. It was hid. It was the fact of it being ratified and adopted and incorporated by Congress was covered up by Watergate.
Had anything about this come out in the recently released JFK files? Anything in regards to it? Has anyone read it?
No, not that I know of. I just happened to, because I've been in the United States wastewater industry since the summer of 73, I guess it was, summer 73 was the first year, was when I went into the business. Well, we know when we were in the business, we went into the business because of the recent ratification of this law. Because that law mandated that all control of all pollutants had to be implemented at the source.
So you were the man that was implementing this, physically implementing this.
That's correct, from the beginning. Yeah, as a matter of fact, I was one of the pioneers in the business known today as rent-a-cans. Johnny on the spot.
No kidding.
I was building outhouses and renting them out because this law mandated it in Alaska out of plywood, loading them up in the back of my pickup truck and taking them out and renting them to the federal government for the parks and recreations.
Yeah, I know a fella in New York who's got a multi-million-dollar business with those toilets, those on-site toilets. And
that's right.
I gotta go.
Rich, he stepped in shit.
I gotta go. Can you send me the sound file, and I'll see if I can make a video out of it and publish it on YouTube.
Yeah, okay, but we can keep sending you information to Glenn and keep feeding you and raising you up to the point to where you can really do the whole thing, and lay it out there.
Okay.
I think it'd be great.
Okay, well that sounds good. I'm interested, but I got some things going. I got to go. But
okay, well listen, let's just cut this thing.
Yeah.
Yeah, let's just cut it then, and we'll pick it up. We'll pick it up another time.
Yeah, right, and we'll get them to you.
Great.
Fantastic.
Okay.
Thank you. God bless.
Appreciate it. Thank you, Glenn. Thanks for your time. Sal.
Okay.
And we'll be talking to everyone. Sandy, thank you.
Okay. God bless. Bye-bye.